Hello, and welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Felicia Lynn. In this episode, we'll be looking at challenges to LGBTQ equality, a year after the Supreme Court's landmark decision legalizing same-sex marriage. We're pleased to be joined today by Tobias Barrington-Wolf, a professor of law here at Penn Law, who has been an informal advisor to President Obama's administration. Thank you for joining us, Tobias.
Thank you for having me.
Of course. As I said, this last year saw the landmark Obergefell decision legalizing same-sex marriage across the country, yet this month also saw one of the worst attacks on the gay community. What does the mass shooting in Orlando mean for the LGBTQ community?
It's a big question. The shooting was an atrocity and a really devastating event. In particular for the Latino LGBT community, who I think feel doubly targeted. This was a hate crime against LGBT people. It was also a hate crime against Latinos. And we are in the middle of an election season where one of the major political parties in the United States is about to nominate a man for president, a candidate for president, who is engaging in open racist rhetoric demonizing Latino people and demonizing in particular Mexican Americans. And the majority of the victims, both the fatalities and the wounded casualties in the atrocity in Orlando, were Puerto Rican, of Puerto Rican ethnicity. And that community in Central Florida is reeling right now. And it's a reminder that when you have a world in which there is still hatred combined with access to military-grade weapons that are designed for the purpose of killing the largest number of people in the shortest amount of time, then there is danger. And so I don't have any particularly uplifting things to say about the atrocity in Orlando. It was a devastating, devastating event.
Well, then I guess let's talk about something that was uplifting, which was last year's Supreme Court case legalizing same-sex marriage. Obviously a watershed for LGBTQ rights, but what are some of the remaining challenges to equality? And maybe let's just start at the federal level.
Well, one of the facts about federal law that most people are not aware of is that gay, lesbian, bisexual, and transgender people don't have any explicit protections against discrimination in employment and in housing in the private sector under federal law. Now, I'm choosing my words carefully. There's a complicated terrain unfolding under federal law, and we can talk about some of the details. There's litigation in various different places around the country, supported by, and in some cases spearheaded by, the Equal Employment Opportunity Commission, that argues that the existing protections of the Civil Rights Act of 1964, and in particular its prohibition on sex discrimination, should be understood to include both anti-transgender discrimination and anti-gay, lesbian, or bisexual discrimination. So that's a big conversation. We can get into some of the details, but there isn't a federal statute that explicitly says that LGBT people are protected from discrimination in housing, or that they're protected from discrimination in employment or in places of public accommodation. And so there are many parts of the country now where there are also no statewide protections, and many parts of the country where there are no municipal level protections. And as a result, you can get married on a Monday, come into work on a Tuesday, inform your boss that you've gotten married and maybe you want to take advantage of the spousal benefits program at your workplace, and be told not only that you're not going to get to take advantage of those spousal benefits, but you're going to be fired because this particular workplace doesn't want to employ a gay person. And there are many parts of the country in which that is still legal, at least insofar as the arguments about protections under the existing Civil Rights Act are still being contested. And so we have not seen the kind of movement on federal civil rights legislation in the last couple of decades that I think many people would like to see, and indeed many people assume are already in place.
Are there any particular federal cases we should be keeping our eye out for?
There's a Second Circuit case called Christensen, where briefing is actually just in the process of being submitted. The EEOC just submitted a brief in this Second Circuit case in support of the argument that anti-gay discrimination is already prohibited in the workplace under the Civil Rights Act. And this is a terrible case involving a guy who, according to the allegations in his complaint, was subjected to really just ugly and systematic harassment and hostility in the workplace by a Neanderthal boss. And so that's a case to watch. There's no question about that. Transgender discrimination, anti-transgender discrimination, has been the subject of even more active litigation in the workplace context, both under the Civil Rights Act and in the case of state employers, there have been a couple of cases under the Equal Protection Clause. It seems likely that one of these cases is going to go to the Supreme Court before too long. It's entirely possible that an anti-transgender discrimination case will be the first case that goes to the court. But so far, all of this litigation has been happening at the district court and the Court of Appeals level.
And so what about at the state level? Obviously, things are more varied at the state level, but maybe you can give us just a sense of the lay of the land, or maybe particular things that particular states are doing that are worth talking about.
Well, let me mention Pennsylvania for starters, the state where we live and work. And Pennsylvania is one of the many states that does not have statewide protection against LGBT discrimination in the workplace or in places of public accommodation. Once again, this is something that many people assume is already in place, and in fact, it's not. There are somewhere on the order of, I believe, 37 states today that have some form of statewide protection for at least anti-gay, lesbian, or bisexual discrimination. A smaller number of states, I think the number is on the order of about 25 right now, have some form of statewide protection that includes gender identity and gender expression. And then there are many cities and municipalities, including Philadelphia, that have some kind of municipal protections, which are, of course, very important, but often are able to confer much less complete relief and are therefore not always fully adequate remedies. So there's a kind of patchwork of laws at the municipal level, the state level, and at the federal level, we don't have the legislation that we need. The Obama administration has taken a number of very important executive actions on issues that are within the scope of their authority, things like limitations or requirements that they place upon businesses that want to do contracting work with the federal government, or protections for people who rent housing that is subsidized by the Department of Housing and Urban Development. Protections for people who seek mortgages that are in some way fall under the ambit of HUD. There are various different executive actions that the Obama administration has taken that provide selective protections in some aspects of the workplace and the housing arena. But once again, it's far from comprehensive protection.
And I guess one particular issue I just want to raise, since you also mentioned it, is immigration has taken such a hold on our public conversation over this past year, particularly given the conversation from the presidential nominees. So I'm wondering if you could talk a little bit about how immigration, predominantly a federal issue, intersects with some of these state issues that you've been talking about in terms of LGBTQ rights.
Sure. One of the biggest issues that LGBT people, and in particular people in same-sex relationships, have struggled with over the years is access to the mechanisms of immigration that have been available for a long time to married couples. We've created a pathway for regularizing your status and acquiring citizenship if you marry an American citizen, if you're a non-citizen who marries an American citizen. And there are mechanisms for treating couples who are seeking asylum, for example, as couples in that process. And for many years, those pathways were not available to same-sex couples at all. And the Supreme Court's decision in the Windsor case, striking down the Federal Defense of Marriage Act, opened some of those pathways for married same-sex couples who are now treated equally in our immigration laws, which is fantastic. But of course, there are many nations where same-sex couples are not able to get married and who may be seeking to either immigrate or to seek some kind of asylum protection, and whose status is still, at the very least, uncertain in those processes. And so when you are talking about the entry point, right, which is a sort of purely federal question, there's been progress, but certainly progress that is not complete. There are some limitations there still. Then, of course, when you arrive, and when you're living as an LGBT person, as a same-sex couple, where you live is going to have a lot to do with how much protection you have from mistreatment or discrimination for the reasons we discussed a moment ago. And if you're also somebody who is an immigrant who has, an immigration status that is not permanent or otherwise is somewhat contingent, then that vulnerability is just magnified all the more.
So let's shift gears a little bit, and let me ask you about your reaction from a legal perspective to those who cite religious objections to doing business with gay people or same-sex couples or sanctioning gay marriage in some kind of official capacity. What's your take?
Well, broadly speaking, there's two different kinds of situation that I think we might discuss. One has to do with participants in the marketplace. Right? Businesses that say, I don't want to provide goods or services to LGBT people or to same-sex couples. And then a second has to do with public officials, right? County clerks who are asked to issue marriage licenses, for example. And my view in both of these categories is that there shouldn't be a special rule for LGBT people. There shouldn't be a special rule for same-sex couples. Whatever answer we think is a sensible answer when it comes to allowing businesses to turn away customers they don't want to serve, or allowing government officials to turn away citizens that they don't want to provide services to, it ought to be an answer that applies to everybody across the board. There shouldn't be a sort of gay exception or transgender exception to the generally applicable principles that we all live by. So for starters, I view this as a question not just about whether LGBT people can be turned away, but whether people can be turned away based upon their religion, whether people can be turned away based upon their race or ethnicity, a whole series of other forms of discrimination that we have addressed both as a legal and as a social matter in the United States over the years. And for starters, I think when you frame the question that way, it causes people to take a step back and think, well, if all of those things are on the table at the same time, then I want to proceed a little bit more cautiously. Now, what do I think the right answer is to those questions? Well, certainly in the context of public officials serving citizens and performing a state function, performing a governmental function, my view is that governmental services should be available to all people, to all citizens on an equal and non-discriminatory basis. And look, I understand that people have individual reasons, whether they're based on religion or just personally held beliefs, for not wanting to acknowledge or not wanting to treat respectfully some of their fellow citizens. I view those as unfortunate views, but I know that they exist. And I don't think that we can be in the business of authorizing government officials to turn away citizens that they don't like. And turn them away even if the turning away means, I'm going to let somebody else serve you, I'm not going to serve you. That is still a kind of rejection that implicates the citizenship status of people who are coming to the seat of government and asking to be treated as equal citizens.
Do you think that's a legally significant difference? In a lot of these conversations, that is a quote-unquote solution that some people raise, that some people will be exempt from serving certain kinds of people, but those people will still receive the government services. What is the legal response to that kind of compromise?
Well, there are a number of responses. First and foremost, as a matter of principle, I think there's some serious questions about whether accommodating discrimination against your fellow citizens is appropriate at all when you are fulfilling a governmental function. There's many different settings in which we have said that the state should not be in the business of validating private discriminatory attitudes. And when you take on a governmental job, you are not acting in your personal capacity, you're acting in an official capacity. So there's an issue of principle right at the threshold. In addition, the idea, I mean, people who defend these so-called accommodation requests often say, well, if you can get the service you're asking for, if you can get, from a private business or from a government office, if you can just get what you're looking for with some minor inconvenience, then what's the trouble? Shouldn't we balance that against the deeply held beliefs of somebody who says, I don't want to serve people like you? And I think the response is that, look, this is a humiliating experience. I mean, I don't know if a person can really understand what it is to be told, we don't serve your kind here. I'm not going to do business with someone like you. I'm not going to allow myself to be associated with somebody like you. I'm not going to symbolically touch a person like you. I'll let somebody else do that. It is an extraordinarily dehumanizing experience. And the fact that it can sometimes be, this accommodation can sometimes be carried out where ultimately you'll get the license you're looking for, you'll get the services you're looking for. It doesn't change the fact that it affects the psychic integrity and it affects the citizenship status of a person who's subjected to that kind of mistreatment. And so I must admit, I understand that people have these views, and I don't think everybody who has views like this is an evil person, just like I don't think that everybody who held segregationist views 100 years ago was an evil person. We live in the times in which we live, and we need to question our beliefs, but we're brought up in belief systems, and that doesn't always make us terrible people. But I don't think that we can allow those kinds of discriminatory attitudes to find expression, certainly in the context of the administration of governmental offices and governmental functions. Now, when it comes to the private marketplace, I have a view which is not shared by everybody, and my view is that, once again, at the very least, if we're going to allow these kinds of accommodations, they should apply equally across the board. And so if you're comfortable with the idea that a small business, for example, can turn away a gay couple because they say they have religious objections to serving a gay couple, you have to be equally prepared to allow businesses to turn away interracial couples or to turn away Jewish couples or whoever else they may say they have objections to. And if we instantiate that principle in the marketplace, I think we need to be ready for the uncovering of a lot more discriminatory attitudes in the marketplace than we may be prepared to assume are going to be there. But second, I think that the public marketplace, when you're a business that holds yourself out as open to the public and benefiting from the many advantages of doing business in the public square, that you should approach all customers, you should approach all people as having presumptively equal moral status. And once again, it is a terrifying thing to be told by a business in the public square, we don't take your kind here. It makes you feel less safe. It makes you feel more exposed to social ostracism and more exposed to physical danger when you experience that kind of rejection in the public square. And I think we have made a decision in our laws that businesses operating the public square should not be able to engage in that kind of selective repudiation of citizens they don't like. And I think that's a good policy.
So there's been a great deal of controversy lately about North Carolina's bathroom law. Can you walk us through this a little bit and then offer your take on these so-called bathroom bills?
Yeah, the legislation in North Carolina was really quite remarkable. It did a whole series of things. This legislation that was sort of pushed through a special session of the North Carolina legislature in very short order. Some of the things that have gotten a lot less attention, this legislation takes away or at least severely undermines private remedies for everybody under North Carolina's existing anti-discrimination laws. So it is suddenly the case that anybody who experiences discrimination in a workplace or in a place of public accommodation in North Carolina may find that they cannot recover for their damages where previously they could have. In addition, the North Carolina law takes away from all municipalities in the state the ability to enact local laws that address forms of discrimination that are not yet addressed at the state level. So the impetus for this terrible legislation was an ordinance enacted by the city of Charlotte that expanded protections for LGBT people against discrimination in public facilities and in public accommodations. And HB2, so-called, the North Carolina state law, reversed or effectively eradicated the Charlotte ordinance. But it did so with an extraordinarily broad restructuring of North Carolina law that said, not only are we going to reject this particular ordinance, we hereby take away from all cities and municipalities throughout the state of North Carolina the ability to enact anti-discrimination protections that are not already covered by statewide law. And so there are no statewide protections against LGBT discrimination in North Carolina. Therefore, no cities in North Carolina can enact such protections either. It's a terrible, terrible policy. And then third, the part of the law which has gotten the most attention is this attention to who uses what bathrooms. And North Carolina enacted a law saying that in all public facilities, that is to say all state facilities, people are, including public schools, for example, people are mandated to use a bathroom or other type of facility that is indicated by the sex that is marked on their birth certificate. And so for transgender people who were born with a gender identity that is at odds with the gender that they're assigned when they're born, they are forced into using the wrong facilities. And they are forced, transgender men who look like men and who are, for all intents and purposes that anybody would have occasion to understand them as, they are men, and in fact they are men, are forced into women's bathrooms. And transgender women who are legally and socially, for all purposes, women, are forced into men's bathrooms. And it is a terrible state of affairs that I think reflects the kind of mindset that often informs anti-transgender legislation, which is a mindset that says, we just want these people to go away. We don't want these people to exist. Because surely it cannot be the case that the people who enacted this law, what they wanted was for transgender men to be in women's bathrooms and transgender women to be in men's bathrooms. Surely that can't be what they wanted. I think what they wanted was to simply force these people out of the public square altogether, to ostracize them and to pass a law that sort of entertains this terrible fantasy that they can be wiped out of existence by legislation. And they certainly can't be wiped out of existence by legislation, but they can be made much more vulnerable. And that is part of what HB2 has done. Now, it's in the process of being challenged under several provisions of federal law that address sex discrimination in the context of public education. It's a Title IX challenge to the application of this HB2 to public schools. And then there's a separate provision of law, the certain provisions of the Violence Against Women Act, which actually prohibit gender identity discrimination directly in the administration of certain kinds of funds that are made available under the Violence Against Women Act for states and municipalities to address gender-based violence and domestic violence. And those challenges are currently being heard by a federal court in North Carolina, and the Justice Department itself is spearheading one of the principal lawsuits.
So I'd like to ask you something that seems a little at odds with what we've just talked about with the North Carolina law, but it seems that over the last few decades, there has been more of a widespread acceptance of the idea of LGBT equality and gay rights in the public conversation. I'm thinking more about in popular media, like the popularity of shows like Modern Family, the generally positive reception Caitlyn Jenner received when she came out and told her story about being a transgendered woman. So how do you think that shift in the way the public generally talks about gay rights now has impacted the legal fight for LGBT equality?
Well, I think it is always the case that social and cultural change or I should say it's almost always the case, that social and cultural change uh, come before legal change. And I mean, I'll use the repeal of the Don't Ask, Don't Tell policy as an example. The Don't Ask, Don't Tell policy was in place formally for 17 years. And prior to Don't Ask, Don't Tell, there had been an anti-gay military policy in the form of regulations rather than a statute that was in place for many decades. And by the time a serious conversation was underway nationally about repealing Don't Ask, Don't Tell, which basically began as soon as President Obama took office, the public polling numbers, the public attitudes towards Don't Ask, Don't Tell were just through the roof. I mean, you got numbers on the order of 70% of the American public thinking that this was a terrible policy that should be gotten rid of. And yet it proved to be extraordinarily difficult politically to garner enough support in particular the United States Senate to put through a legislative repeal of this policy. And it required a year-long effort by the president and his staff in the White House, working in conjunction with advocates and heroes in Congress. And there was just an enormous amount of legislative resistance. And I think it was born partly of the fact that anti-gay and anti-transgender discrimination is just so ingrained in certain components of our politics that it's become habitual, it's become familiar, and there's a fear. I mean, I think some legislators are just true believers and have deeply anti-LGBT attitudes themselves. And even for those about whom that might not be true, they think that this is some kind of third rail. They think that if they touch this issue, then they're going to suffer political consequences. That turned out not to be the case with the repeal of Don't Ask, Don't Tell. And so this may be shifting, but in the wake of the Obergefell decision, we have just seen an avalanche of legislation, in state legislatures that seem to be deeply committed still to anti-gay and anti-transgender pandering. And I think they are demonstrably out of step with the times, but it's not yet politically dangerous enough for them to be engaging in this kind of anti-LGBT advocacy and pandering. And I think that for some of them, it curries them favor with their party or with their base. And so we have indeed seen a lot of progress, both legal progress and social progress. But there's a heck of a lot of LGBT people, particularly in hostile states, who are still very vulnerable.
Well, what are some bright spots or reasons for optimism you can point us to?
Well, I think that we are very close, maybe even days away from an announcement from the administration that the anti-transgender policy in the U.S. military is going to be lifted. That has been underway for quite some time, and I think there's reason to believe that an announcement is imminent, which is very exciting. We have certainly seen in the context of healthcare, this has been very much below the radar screen, but under the Affordable Care Act and under some of the implementing regulations that have carried the Affordable Care Act into effect, there are protections for LGBT people, particularly for transgender people, in accessing healthcare services, in accessing transition-related healthcare services or services that are specific to transgender health needs that are now explicitly protected under regulations that were promulgated by the Department of Health and Human Services just earlier this year. And so we are beginning to see LGBT people more broadly and trans people in particular drawn into a functioning healthcare system for them, which is a huge advance and very important, particularly for more economically vulnerable LGBT people. The Obama administration has implemented a comprehensive national HIV/AIDS policy. And while the HIV/AIDS epidemic is still an urgent priority, and in particular among young men of color who have sex with men, the transmission rates are still shockingly high, and that has a lot to do with access to quality health care. Nonetheless, we are seeing a national coordinated response to the epidemic in a way that we have never seen before. So in the field of healthcare, I think there has been enormous advancement over the last several years.
Well, we started our conversation talking a little bit about the election, so maybe we should end our conversation there too. What is your analysis for prospects for LGBTQ equality, depending on who wins the White House and also depending on who takes the majority in Congress?
Well, I'm afraid that I'm not exactly going to pull my punches in talking about what's at stake in this presidential election. The GOP is about to nominate a sociopath and a fascist who has no concern, as far as anyone can tell, for anything relating to the public good, and is simply some kind of emotionally broken man-child who seeks to puff himself up at every turn, and who has shown a willingness to throw aside huge swaths of the American community if it can whip up a base of supporters. And he is a threat to our democracy of a type that I've never seen in my lifetime. And so I almost am reluctant to focus in particular on the threat that he represents to LGBT people, which I think is profound, because he represents such a threat to the fundamental principles of our representative democracy that I think we need to be speaking in broad terms in describing what his election would represent. On the other hand, Secretary Clinton is a career-long advocate of LGBT issues. She has not always been in the right place on a lot of important issues, and like many public officials, she has shown progress and growth. But I think it is fair to say that there are very few, if any, major LGBT initiatives that she is not squarely in support of at this point. I have not over the years been a huge supporter of Secretary Clinton's, but I must say I've come to admire her a great deal. And the prospect for continuing the embrace of LGBT people as full citizens, which happened for the very first time in American history under President Obama, I think that Secretary Clinton will unquestionably carry that progress forward. I think there's no doubt about that. As for Congress, as I mentioned earlier, we do not have federal anti-discrimination protections in the context of public accommodations, and we don't have explicit protections in the context of the workplace, and we don't have protections in the context of housing. These are all major initiatives that are drawn together in proposed legislation called the Equality Act, which is pending in Congress now, which has no hope of getting a hearing under a GOP-led Congress. And if the Democratic Party were able to regain both houses of Congress, there would be an opportunity to advance that legislation. So on a purely sort of legislative level, there is a lot at stake where the November elections are concerned. But once again, I think it's not responsible to talk about what's at stake in these elections without using very strong language to describe the threat to our democracy that the GOP prospective nominee represents. And I think anybody who cares about democratic values needs to be alarmed at what's at stake in this election.
Well, we'll have to leave it there. Thank you again, Tobias, for joining us for this illuminating conversation.
Thank you so much. It was a pleasure.
And thank you for watching Case in Point.